If you're a truck driver and you've been injured in a crash in Wisconsin, this situation is different than a typical car accident. In this video, I will walk you step by step through the entire process from the moment after the crash until the final resolution of all claims. But before we begin, my name is Craig Steger. I'm a personal injury attorney practicing in Wisconsin, Minnesota, and Iowa. I've handled injury cases for over 20 years, and I also hold a Class A CDL. I understand both sides of trucking cases, both the liability side and the injury side. Now let's start with what you should gather as soon as possible after a crash. If you hire an attorney, your attorney will do a lot of this for you. In trucking accidents especially, it's important to preserve key evidence from the crash scene. But even if days or weeks have passed, it's still possible and important to obtain and preserve some of the following things. Probably number one is the police file. You want to request the full crash report. It usually contains important information like drivers' names and their contact information, employers, insurance information, witnesses, who owns the vehicles. It'll include observations of the officers themselves. It may indicate road and weather conditions, time of day, whether citations were issued. Now, if you were issued a citation from a trucking crash, speak with an attorney immediately. A conviction on a traffic ticket can affect your possible civil injury claim or your ability to defend a claim made against you. It can affect your CDL record. It could affect your employment. If there was a DOT inspection, you will want to make note of whoever was there present and try to obtain copies of their inspection reports. At a minimum, try to get a business card if you can. In trucking cases, the crash report often becomes a central document for insurance evaluations. Second, I want to talk about video evidence. If your truck had dash cam footage, make sure that you preserve that. That would include both inward-facing cameras as well as outward-facing cameras. Make sure that gets preserved. There may also be police dash cam footage or body cam footage. That's something you usually have to request in addition to the crash report. Sometimes, depending on where the crash happened, there may actually be surveillance camera footage from local businesses and gas stations, especially gas stations. So make note of that right away. They tend to not keep that for more than about 30 days and then it gets written over. So it's really important that you or your attorneys try to gather that as soon as possible. Depending on the age of your truck or the other vehicles involved, there may be electronic control modules and black box data. That has to get downloaded before it gets written over, or that can get lost. There may be telematics data, electronic logs. If you were employed by a motor carrier, you need to notify them immediately that you want this data preserved. They may already be doing that, but don't just assume. The black boxes on modern trucks will usually record the last significant braking event, but they only store so many events, and if the truck is repaired and put back in service before that data gets downloaded, those events can be written over and lost. I've seen that happen. This is especially critical in trucking cases where you can bet someone will try to blame you for the crash, even if you were injured and even if it wasn't your fault. Let's talk about photographs. Try to preserve all photographs that you can find and take photographs if you're able to do so safely. You want to try and get photos of the vehicles, where their positions are at the final rest. If possible, get photos of the point of impact and the locations of the vehicles at the time of impact. You want to have photos of any damage to your tractor and trailer, to any underride or override damage, any shifting of loads in the trailer as well as inside your cab. You want to try to take pictures of any road conditions, if any airbags deployed. Try to take pictures of nearby road signs and traffic signals. Are they working? What's the speed limit? Who had the right-of-way? Keep copies for yourself and don't lose them. If it's possible, take a video of this scene, because that can be really, really helpful later on if people are wondering what actually happened there and what was said. But be very careful about recording when you're talking. Let's talk about insurance documents. One of the most important things to gather at the beginning of any of these kinds of cases is insurance information. That would include the other driver's insurance information. It may include your own personal auto policy that may or may not apply depending on your job situation, your employer's commercial auto policy, any occupational or accident coverage you may have, your workers' comp policy if you're eligible for workers' compensation, and really any other insurance policy that may apply to your truck, trailer, or the load. Typically, commercial trucking policies have to be a minimum of $750,000, but most carriers will have additional layers of insurance beyond that. Do not give a recorded statement to another driver's insurance company without legal advice. You may want to consult with an attorney before giving a statement to your own insurance company. You should assume that any statements you make to your employer, their insurance company, the police, or DOT will be used against you in a future lawsuit if it's not helpful to you. Let's talk about medical records and bills. If possible, and your attorneys can help you with this if you hire an attorney, you want to get things like ambulance records, ER records, any imaging studies, MRIs, X-rays, CT scans, any discharge summaries from the hospital, specialist evaluations, therapy notes, surgical reports, itemized billing statements. Your medical documentation is going to be the foundation of any injury claim you may want to pursue. Let's talk about wage and income loss. Truck drivers often have much more complicated income structures. You want to try and gather and make sure you keep things like settlement sheets, mileage logs, receipts, pay statements, 1099s or W-2s depending on how you're paid, your load history, keep your tax returns if you have them, receipts if you have to rent a replacement truck or subcontract your loads to another driver while you're out of service. Lost earning capacity is often a major part of a truck driver's injury claim. Let's talk about medical care and treatment. Medical treatment is going to be central to your claim as well as your CDL. It's really important not to tough it out. Insurance companies really look for things like gaps in treatment, delays in follow-up, missed appointments. If your injury affects your ability to drive commercially, to maintain your CDL, to load or unload your loads, to climb into the cab, to handle tarping and things like that, to perform mechanical tasks on your truck, make sure you ask your doctor for written work restrictions. These records could really matter. Now, who pays your medical bills? For injured truck drivers, there are usually multiple possible payers. If you were on the clock at the time and you're eligible for workers' compensation, you may be eligible for workers' comp. Workers' comp typically pays things like medical bills and a portion of your lost wages, even if the crash was someone else's fault or even your fault. If you have health insurance, you may want to use your own personal health insurance to cover your medical expenses. We'll talk about that in a little bit. Third party, if you have a third party claim, if another motorist caused your crash, you may have what we call a third party claim in addition to your workers' comp claim. That's a personal injury claim against the other driver, whether that's another truck driver or another motorist. This can mean that your workers' comp may pay first, and then a third-party claim, insurance company, may have to reimburse your workers' comp or your health insurance. Now, you may be able to recover additional damages not available under workers' comp if you have a third-party personal injury claim against another driver. Now, see, these different systems overlap and must be coordinated carefully by your attorney, if possible, to maximize your coverage and put the most amount of money in your pocket. If one insurance policy pays benefits and then there's a later recovery against a third party, they will usually be entitled to some type of reimbursement, and we call that subrogation. After a while, once you get through your treatment, usually we're looking for something called maximum medical improvement, MMI. MMI means your condition has stabilized enough for doctors to determine whether you have permanent impairment, whether you're going to have any future medical needs, or any permanent work restrictions. Serious trucking injury claims are typically evaluated after an MMI. You may have a question about, do I have a case? And so for truck drivers, this question has a number of layers. There are three core questions. Who was at fault? Was there an injury? And is there insurance to cover it? You see, Wisconsin follows a modified comparative negligence system, which means if you're 51% or more at fault, you generally cannot recover damages. If you're less than 51% at fault, your recovery will then be reduced by your percentage of fault. This is for injury claims. This would not apply to workers' comp coverage. Fault is especially important in trucking cases because as the truck driver, you're subject to a lot more rules and regulations than the average motorist. It is very common in trucking accident cases where fault is generally in dispute to need accident reconstructionists to analyze the data, make measurements, and form conclusions as to the exact cause of the crash. If you're going to hire a lawyer, the sooner you do so, the sooner they can get an accident reconstructionist involved to make sure they have all of the information they need to sort out exactly who was at fault in causing the crash. If someone else, if a non-trucker was injured in a crash and they bring a claim against you, you can assume they're going to dig deeply into the trucking rules to try to show violations against you and your employer. The trucking company's insurance carrier will hire lawyers to defend you and the trucking company if there's a lawsuit. But they can't really help you if you have your own personal injury claim. If you were injured in a crash where other people were injured, you'll be entitled to have your own injury attorney who is advocating on your behalf for your own injuries and losses. Something important to note, you may be named in a claim or a lawsuit if another motorist was injured. They may bring a claim against you, a claim against your employer. They may file suit naming both of you. In those situations, your trucking company or the insurance company will hire a defense for you. But you can also simultaneously pursue your own personal injury claim. Sometimes we collaborate with defense counsel on liability claims to ensure that your rights are protected. You may be entitled to a claim for damaged or destroyed goods that were being transported, as well as your own injuries and medical expenses. Now, you and your attorneys will also need to deal with these claims and coordinate them with any insurance you have that may cover that if there are damaged goods or delayed shipment. Various tracks of insurance must be handled carefully, and it's very helpful to have an attorney involved as soon as possible in the process. Now, you may be asking, how much is my case worth? Well, there is no universal formula. Value depends on a lot of different things. Things such as the severity of your injuries, whether there's any permanent restrictions or permanent injuries, whether it impacts your CDL, such as your loss of earning capacity, things like your age and your work life expectancy. Damages typically fall into two categories. First, we have economic damages. Those are things like medical bills, past and future, lost wages, lost earning capacity or lost revenue, damaged or destroyed truck, trailer, and equipment, replacement truck and or driver when you're out of service, lost or destroyed cargo that you were hauling for someone else. For truck drivers, a loss of a CDL or permanent lifting restriction can significantly increase your case value. So those are what we call economic damages, usually things that can be quantified readily through estimates, invoices, receipts, things of that nature. The other big category of damages are what we call non-economic damages. These are things like pain, suffering, disability, emotional distress, loss of enjoyment of life, loss of consortium and relationship with your spouse. Insurance limits are very, very important. Commercial insurance policies are typically higher than passenger vehicles, but the coverage structure matters. It's really, really important to know as soon as possible what are the different types of insurance policies that may apply to your situation in your accident. I want to talk a little more about workers' compensation and possible third-party claims. So in truck injury cases, there are often two parallel claims. First is your workers' compensation. That typically covers medical bills, temporary disability benefits, and permanent disability ratings. It doesn't usually pay for things like pain and suffering. It doesn't usually fully replace your wage loss. A third-party claim is if another driver, whether that's another trucker or another car, caused or contributed to the crash that you were injured, you may also pursue an injury claim. Here you can seek your full lost wages, pain and suffering, future earning loss, the full measure of your damages. In those cases, if workers' comp has paid benefits, they'll usually have a subrogation interest and may have to be reimbursed later on if you pursue a claim and make a recovery against another insurance company. These types of cases require a lot of coordination between your insurance, the other driver's insurance, your workers' comp. That's why it's really, really important to have an attorney involved as soon as possible to help you with that. Now, as truck drivers, you face additional regulatory concerns anytime there's a crash. Depending on the crash, there may be DOT reportable accident reviews that have to take place, post-accident drug and alcohol testing, FMCSA safety investigations. There may be impacts on CSA scores. Your logbooks may be scrutinized. Hours of service may be looked at. Statements made to insurers or investigators can have regulatory implications, so be careful. It's important to understand your obligations to avoid inconsistent statements. Protect both your license and your civil claim. In some cases, safety audits or internal investigations can occur. Process is often run parallel to your injury or workers' comp claim. I want to talk a little bit about how personal injury attorneys are hired and how they're paid. Most injury cases are handled on what's called a contingency fee basis. That means that you don't owe a fee unless there's a recovery, whether that's a settlement or after trial. The fee is typically a percentage of whatever is recovered, usually between 30 and 40%, but it can depend on the type of case it is. You want to always review the written fee agreement that's presented to you by an attorney. You want to ask whether you're responsible for case costs and expenses, even if there's no recovery. Find out if the lawyer has represented injured truckers before. The consultation for talking to lawyers is free, and so you should feel free to talk to multiple lawyers and ask around and find the one that's the right fit for you. When you get to the point where you need a lawyer, I want to talk about the types of things that a lawyer is going to need from you. Typically, they're going to be looking for things like the crash report, your employment information, insurance information, medical records, medical bills, wage loss documentation, logbook data, all the stuff that we talked about before. As soon as you hire an attorney, they can actually go ahead and gather these things for you and take that work off your plate. Now, there are legal deadlines that you need to be aware of. So in Wisconsin, the general statute of limitations for personal injury is 3 years from the date of the crash. If there was a government vehicle involved, there may be additional notice requirements that can apply, sometimes as soon as 120 days afterwards. An attorney can really help you with that. Workers' compensation claims may have separate deadlines. Missing deadlines can permanently bar your claim, so it's really, really important to talk to attorneys as soon as possible. I want to talk a little bit about the claim and demand process that can usually lead to a resolution of claims. So after your treatment has stabilized, you've reached MMI, claim will be opened with the at-fault insurance company. They're usually going to be notified near the very beginning that there's a claim, and your attorneys will be providing them with wage information and medical records on an ongoing basis. But once you've kind of done treating, your attorneys will put together a demand package for you. And this will include things like the crash summary, a liability explanation, and why your attorneys believe that the driver for the other insurance company is at fault. They'll include your medical bills and summaries, your bills, lost wage calculations, future restrictions, and you'll include a demand in there that will be agreed upon by you and the attorneys and presented to the insurance company. Once the insurance company receives that, they may accept it, they may reject it, and they may offer a counteroffer. They may request additional information or documentation. This can go back and forth multiple times. At the end of the day, you have the final say on all settlement decisions. Now, sometimes settlement can't be reached, or maybe you're not done treating before that deadline comes that legal action needs to be taken. In those cases, a lawsuit may be filed. If another driver has already brought a lawsuit against you, you may include your injury claim as what we call a counterclaim, which means you'll both have your own injury claims in the same lawsuit. You can also file a separate lawsuit for your injuries, but courts will often consolidate those cases anyway. Now, a filing of a lawsuit does not mean that your case will necessarily go to trial. In fact, most cases actually settle before trial. We call that litigation. So litigation starts with the drafting of a summons and complaint. That's the legal documents that put the other side on notice that a lawsuit is being pursued against them. Those documents are then served on them or the registered agent by the police or a process server, and then they'll have time to answer. They'll then file an answer in the case, and then both parties will do what's called discovery. That's exchanging written requests for information and documents. At some point, there'll be depositions scheduled, typically of you as well as the other parties, sometimes expert witnesses and your doctors. Experts may be involved if they weren't already involved to support your case, things like accident reconstructionists, truck safety experts, medical experts, economists, vocational experts. Usually at some point during the litigation, the parties will come together for what's called formal mediation. This is in front of a neutral third party, often an experienced lawyer or maybe a retired judge, who tries to help the parties to see if they can reach a resolution. And a lot of cases do settle either before or at mediation. But if mediation is unsuccessful, then you'll go to trial. And your attorneys will be doing a lot to get your case ready for trial. Usually this will be in front of a jury. The jury will then be asked to decide issues such as fault, percentages of fault, and ultimately what your damages are. Now, after a settlement or after a verdict, if you're successful, certain things will have to happen before monies are paid out. Workers' comp and other subrogation liens will be addressed and satisfied. Health insurance companies may be repaid. Case expenses that your attorneys advanced may be reimbursed. Your attorney's fees will be paid. You'll be paid the final settlement out of that. All of this will be done with your knowledge and consent. If you are an injured truck driver in Wisconsin, your case is more complex than a typical car accident. If you have any questions about any of this, you should speak with an attorney experienced in truck injury cases so you understand your options clearly. If you'd like to learn more about working with me, just call or text the number on the screen or go to the description for more information.